Hi there, I'm Michael Bovee with Consumer Recovery Network, and thanks for tuning in to our YouTube channel, DebtBytes today. Today, I want to talk about a question that was submitted by one of our viewers just a few days ago, and it has to do with when you have a judgment debt against you, what to do about debtors examinations and or some of these questionnaires that you might receive from the collection law firm when they're trying to collect from you. So, first off, you should talk with an attorney in your area, somebody in your state, preferably somebody that knows debt collection defense, so that they can inform you of some of your options to resolve the debt and or deal with the collection in the court and answer your questions about, should I fill this out? Am I compelled to fill this out? What happens if I don't send this back? And so in general, one of the reasons that I'm very motivated to do this video, even though you should probably talk with an attorney as well, is to caution people when they receive something directly from the court. This type of debtor's examination that is compelled by the court, when you receive a notice to appear, and it is the court sending you this notice to appear, then if you ignore that and don't show up, you can literally end up with a bench warrant against you. So, there was a couple of reports that highlight this kind of activity. We don't have debtors prisons in the US anymore, but for all intents and purposes, there are things that can happen that lend to the appearance that we still have that. And that is these bench warrants that are issued. So there are several examples of where a consumer didn't show up for one of these debtors examinations that were, again, compelled by the court, that they got pulled over, and they run your name when you get pulled over, and they were hauled off to jail over a debt collection issue, a civil collection issue of less than $1,000, a couple $100 issue, and the next thing you know, you're spending time in jail, not because you owe a debt though, not because there's a judgment that went against you that you've largely ignored because probably you didn't have a choice, but because you were noticed by the court to appear so that they could essentially try and learn how that they're going to collect on the judgment, the plaintiff, and you didn't show up. So it's different when you receive something in the mail from the collection attorney law firm that is kind of a questionnaire. It's like, hey, fill these out for us. And these questionnaires are designed to provide the law firm information about you that's going to make it easier for them to collect. So things like, where do you bank? Where do you work? What do you make? What do you own? And these kind of details are certainly going to give someone more motivation to come at you with the extraordinary collection rights that they have afforded to them that are very state specific. Some states don't allow wage garnishment, only a handful, most do allow it. And so they want to garnish wages, they want to levy your bank account, they want to find out what non-exempt assets that you might have pursuant to your state's law that they could go and try and collect from you. It's a pressure tactic for the most part, and it works. Why would you fill it out? Well, I'll tell you what. If you have a situation, and many of our viewers will, where you're unable to pay, you're not working, you're on a fixed income, you really don't have any assets, giving them information that supports your position that you can't afford to pay is not a bad idea for the most part. But giving them information that suggests to them that you're more of a collection target is a bad idea. The way to deal with this is often just resolve the debt. Judgments aren't going anywhere. A lot of misinformation online, or people misconstrue information that they read about the statute of limitations, where, oh, it's going to fall off my credit in 7.5 years. The judgment won't bug me anymore. Wrong. There is a statute of limitations on judgments, but they're renewable for the most part in most states. So thinking that you can just wait this out and it's going to go away is not a good idea. In some states, they're renewable every 10 years for life, right? Every 5 years for life. And they're not something that the attorneys forget to do, and it doesn't even cost anything much anymore. So you used to have to send court runners to do all this stuff, right? Now it's online, so it's inexpensive. It is something you can just set a calendar item 90 days prior to the expiration of this judgment to renew it. So getting hopped up on hope that this is just going to go away if you're able to survive collection long enough is the wrong approach. There are some very limited states where that might apply to you. Most of us, it's not going to. So ultimately, you have to come up with a plan or a design to deal with this. Sometimes it's bankruptcy. Chapter 7 wipes out the judgment. Chapter 13 could wipe out a lot of the judgment and other debts. Settling is we talk about that. We have videos up on our YouTube channel about settling when sued, after sued, very specific to creditors. Some of the law firms we'll cover more in the future. So do a search on some of your particulars, or just post some of your details in the comments below, and we give dedicated feedback to everybody that posts on our YouTube channel. Remember, reach out to an attorney if you have a concern about what you received from an attorney about a court matter, or what you received directly from the court about an existing court matter. It's important. See you on the next video.